Right.
So if we can open it up a bit, then...
Sure. Why don't you come and moderate?
Okay, yeah. Would you have questions then? Because there were some of you who asked about specific legal actions that would be taken at the state level. Or if there are specific questions to him on the case, ongoing case, or on the biosafety rules existing today, which are only administrative and executive orders under the Environment Protection Act. So I mentioned just now that we had the biggest chemical disaster with Bhopal, where we haven't been able to pin responsibility on a multinational company. It was after the Bhopal disaster that in 1986 the Environment Protection Act was set up. The rules under that on biosafety were made in 1989. We are now in 2010 and we have our socio-political economic context very different. Are we equipped? Do we have a regulatory regime which can take effectively cover all these concerns that we've come up with today?
If there is any question or any comment or whatever, you can.
Also, what's your take on the case of family use of it?
Yeah, in fact, there is a appellate tribunal which had been created, which was to hear appeals, or which is supposed to hear appeals against the decisions of GAC, etc. GAC, the decisions of the under the environmental impact clearance, etc. Now, what happened with that body is quite interesting. See, that body, that tribunal was supposed to be headed by a judge of the Supreme Court or retired judge of the Supreme Court, something like that. A retired judge who would be given the status of a Supreme Court judge. They never appointed any such person. Throughout, it remained basically a one man or at best a two-person show. It was supposed to be a multi-member body, but mostly there was only one person manning it, and for a long time the person manning it was the person who had himself been the secretary in the Ministry of Environment. That means he would sit and appeal against his own decisions. Most of the decisions which would be coming up before him in appeal would be decisions against the Ministry of Environment granting environmental impact clearance. And he would sit and appeal against his own decisions. And we found actually Ritvik Datta, one of these, our sort of most experienced environmental lawyer, who has done a lot of cases before this body, the Environment Appellate Authority, says that they gave no relief virtually even in a single case. Not a single case did they go against the government, even though there were all kinds of problems, particularly with environmental impact assessment. Of course, this case against GAC did not go there, but there were a large number of cases against environmental impact clearance which had gone there. But in each case, they dismissed it either on some technical ground or on some other ground without even going into the issues which had been raised. And that is why even the Delhi High Court came down quite heavily on this authority in a number of cases recently. The present Chief Justice of the Delhi High Court, who is a very competent, very good judge, Justice A.P. Shah, has had the occasion to make large number of remarks against that authority. He has also directed that the authority must be filled up by a judge. The chairman of this authority must be a retired judge. But nothing has been done. Now, of course, the government is saying that they will create this biotechnology, which Kavita will talk about, Biotechnology Regulatory Authority, RAI. So that's the position regarding that. Of course, ideally, you are right, if there were a truly independent and competent authority, an appellate authority, that would certainly be very useful and that would take the load off the court. We wouldn't have to go to the Supreme Court. We have had to go to the Supreme Court for this, partly because we are, of course, wanting to frame rules. We are saying that right now the whole system of regulatory clearance is not correct. You have to put in place various checks, safeguards, transparency, etc. in this whole system. And apart from that, we wouldn't even go to this authority against a particular approval because we have no confidence in the authority as it exists today. One of the problems with all these authorities is the manner in which people are selected. In fact, this is a problem which is common to not just this authority but to all the various tribunals, commissions and so on, that the appointment of members to those bodies is totally arbitrary. Usually they are used as post-retirement jobs for the friends of the Chief Justice or the friends of the Law Minister or the Environment Minister, without any regard to the requirement of that job and the competence of that person who is being appointed. So it's all being done very, very badly.
Could we now request Kavita to finish up on the NDRA and thereafter then open this up to this, raise the issue and start the discussion on that.
Add a few more things to this, and I would argue that it's not just about intergenerational effects, but I think any ideal law around environment and environmental negative implications should take into account intergenerational equity. I thought that was what they were raising there. That intergenerational equity should be a very important component there. And in Norway, the Gene Technology Act, to begin with, like Shalini was pointing out, in India there is no separate statute. There are only those executive orders of the 1989 rules of the Environment Protection Act of 1986. And we have found that they do keep changing some of those clauses as and when it suits them. For instance, there was one morning when GESC woke up and said, we will not look at GM food imports anymore. It's not our responsibility at all. Without anyone hearing anything about it, they just put out a notification saying that anyone can import. It was deregulated, so to speak. No one was looking at it for almost 6 months before, other people had to step in and say, no, you have to do it until another body takes over. Things like that have happened. So no separate statute in itself is an issue. 1. 2, earlier we were talking about a federal structure where state governments also have authority, a constitutional authority and responsibility towards agriculture. But today's 1989 rules in India don't allow much space for the state governments to have any say in it. In fact, state governments are in a position where they don't have any legal authority by which they can declare themselves GM free and stop the center from conducting trials in their states. Only when a state government officially passes a policy level decision, as has happened in the case of Kerala, where the cabinet had said, okay, we are an organic state from now, we are a GM free state. Apart from that, no authority exists really to stop trials from taking place, to have their say when the center is taking a decision and so on. So I will add state governments as an important element and their constitutional authority. Intergenerational equity is another aspect. Like I was telling you, in Norway, the Gene Technology Act, as part of, you call it testing, I call it impact assessment or whatever, clearly asks a question which every GMO developer has to answer, a question that says, is this ethically and socially justifiable? And they have not left it just as a question question which is vague and abstract. Under the statute, they have actually put a framework of answering those questions under different sub-parts and so on. It is included in the statute that some GMO can be allowed only if it is ethically and socially justifiable. So that is something that the regulatory body asks and tries to answer. That I think is something that's missing here. This important point about how research has to be clearly regulated and how release then has to follow it if the other parameters are met. Your precautionary approach has to work. Your point about are there no other alternatives before we go in for GM and so on. After you have gone through that, there needs to be an assessment about whether we need to have separate rules governing release and so on. That exists in other countries. Once again, I will invoke the Norwegian Gene Technology Act. It clearly allows for deliberate release only after all those questions are answered. Here in India, they argue that we would like to do open air trials even as we are assessing biosafety. These are run as parallel processes and not in a sequence. They say that we need that much of testing material to be generated to feed those experimental animals, whether it's rats or rabbits or goats. That's why allow us to do it in open air conditions. It's a very vicious kind of a cycle. On the one hand, we don't want them using surrogate proteins. We are saying if it's really that important that this product be released, then the responsibility lies with you to grow as much plant material as is needed in contained conditions. Just because you want to test it, it can't be put out into the open where it can contaminate, where it can become an uncontrollable situation even before it is proven to be safe. So there are all those issues with the existing legislation, with the existing regulatory regime, the testing regime, liability for instance. At the most, the EPA's 1986 clause of liability applies, but we have tried repeatedly to take violation cases to the regulators, and we find that they don't want to apply even the EPA thing. The 1989 rules expressly don't have anything more to say on that. Forget about remediation, compensation and so on. That just does not exist. In fact, there have been many BT cotton growers in this country who have not obtained any compensation, not even under the existing seeds legislations, leave alone under a separate GM legislation. So all of these are very important elements that are missing in the 1989 rules. On top of that, now they are saying that they'll bring in a new legislation. They also say that yes, a separate legislation is required, and they want to bring in something called the National Biotechnology Regulatory Authority. And this, the draft bill has been put out in May 2008, and it had sought view on BT cotton, for instance. Even if we all agree that, let's assume for a second that it is safe, we found that it cannot tolerate stress. When there are extreme weather conditions, high rains, low rains or whatever, the product is technically safe, let's say, but it affects the livelihoods of farmers because of the genetic engineering process that it underwent. Then there are issues related to livelihoods. Therefore, socio-economic impact assessment is something that has to be part of this kind of regulation. Beyond that is the Norwegian thing of socially and ethically justifiable. The ethical part was also included in the Norwegian thing. So we've always argued that this is not just about biosafety, this is biosafety and beyond. It's about larger impact assessment that's required. But the driving force has to be that of, we need to regulate because we want to protect the health of people of India, because we want to conserve and protect the environment. That has to be the main mandate of any legislation, right? So all these are issues that have to be already covered. There's also no policy framework in India which governs GM. Well, I guess there is one which is only supportive of GM and does not say anything precautionary about GM. This is the Environment Protection Act, where the preamble of the 1989 rules clearly say, with a view to protecting the environment, nature and health with the application of gene technology. So this is what, a minimal kind of a thing that exists right now. And then we'll move to the NBRA. These are all part of the existing 1989 rules. The different committees that have been created under those rules. This is crazy. In fact, there are supposed to be state level committees, district level committees and so on. The idea that we should have a separate legislation and set up a separate regulatory body at the national level came from a task force that was set up by the Ministry of Agriculture and headed by this Dr. M.S. Swaminathan. Prashantji was just describing about Swaminathan. And that task force report said that any biotechnology regulatory body in this country and the regime, as a bottom line, should have these things: safety of environment, well-being of farming families, ecological and economic sustainability of farming systems, health and nutrition security of consumers, safeguarding of home and external trade. This is also important because the majority of countries around the world have rejected GM. So if you allow a GM product, your export markets could very well be affected, and that means impact on the livelihoods again. And biosecurity of India. This is also a concern because this technology can be used to unleash bioterrorism. You can create a lot of problems by releasing these viruses, bacteria, these changed, modified organisms and so on. This was the central recommendation of that committee when it said, do set up an NBRA. There were many other problems in that task force report, but I am giving you the bottom line of what they said should be the central tenets of any regulatory authority. And then they said, they will create a legislation, and why will they do it? Not to protect our environment and health. They will do it to establish the NBRA of India and to regulate the research, manufacture, import and use of products of modern biotechnology. You already see a great dilution in what the mandate for such a legislation should be. And then it goes on to say, why they think there's a need for a separate legislation, and it is very unabashedly, very openly, shamelessly saying that biotechnology is needed. To promote biotechnology, we need a legislation of this sort. So its very preamble and objective itself is very problematic the way it was proposed in 2008. We pushed it back so badly that we don't know where it lies now, this bill, and in what shape it is. It says very clearly, and whereas the government of India wishes to promote the safe and responsible use of biotechnology, there are many questions around this articulation of the preamble itself. So this is what they are proposing that they will do by setting up a national authority. They're saying that it will have three different wings. One is for agriculture, fisheries and forestry. This is the open release of all those products. Another is human and animal health branch, which is the pharma and veterinary uses of biotechnology. Like we were saying this morning, biotech is used a lot in producing medicines, vaccines, all those things right now. And the third is industrial and environmental application branch. This use of biotechnology also you must have heard of. They are using microorganisms and biological methods for a lot of environmental applications. They say that for cleaning up a particular toxic waste and so on, we need some of these modern biotechnology tools. So they are saying that they will have a chairperson for this NBRA, which will have 3 distinct wings, and these 3 wings will be for 3 sectors, if you like, where biotechnology is mostly used. And they have proposed that all the 4 people, the 3 unit heads and the topmost guy, they will all be scientists and biotechnologists themselves. So we're talking about a structure where more and more in this world, people realize that this kind of reductionist approach, where expertise in one's own specialization is really missing out on a holistic picture when it comes to technological applications, when more and more realization is at least being articulated in academic papers and so on, India wants to set up a legislative regime and a regulatory regime where all the key people in this NBRA will be subject specialist experts. They will be biotechnologists and so on. And they are also saying that they will have state level units, yes.
What do you propose they should be? If not experts or specialists in their field, what do you propose they should be?
We are proposing a multi-sectoral body to take decisions. This is not just about safety. The existing body, Genetic Engineering Approval Committee, if only it was not laden with so much inefficiencies and conflicts of interest, actually has represented, it does not have farmer and consumer representatives. Granted, it's not broad-based enough to have that kind of representation. It recently started including social scientists, legal experts. It has representatives from different kinds of ministries, Ministry of Health, Ministry of Food, Ministry of Commerce and so on. What they are proposing here is not a broad-based body. They are talking about a body which will clear biotech products in this country based on just technical evaluation, and that too with people, let's say, who believe in those areas of expertise almost blindly. Biotechnology is an area where there's actually what one would call as contradictory science. There's no one stream of evidence that is emerging there. And if they don't consciously say that even within this narrow framework of technical evaluation of something or the other, if you don't consciously integrate contradictory science, this could be disastrous. The fact that they are saying that it will have subject matter specialists. But that's not the fundamental issue with this. I'm just going to list out a whole lot of things. That is one of the problems. They're also talking about a separate risk assessment unit that they set up under the NBRA. For the first time, they are saying that they will do independent research. That's the little positive element in this. So far, all the research that has happened has been something that has been generated by the crop developer, the ones who want to finally market the seeds. And they produce the data and give the data to the regulators. It appears that the regulators don't even read it. One set of regulators, it appeared as though they don't even have access to that data. It's all being kept by one body in the DBT, which is called the Review Committee on Genetic Manipulation. But at least, there's not even been an independent analysis of the data given by the crop developer, like he pointed out. Under the NBRA, they are saying that they will do independent research and independent analysis, and no crop developers will sit here. Okay, they are saying this is to remove conflicting interests in the regulation. Fine enough. But where do they want to house this entire NBRA? It will be under the Department of Biotechnology. That itself is a major conflict of interest, because the Department of Biotechnology's mandate is to promote biotechnology. And this body being housed there could, that also means that when institutional structure for regulating is housed somewhere, that also will have its funds flowing, its resources flowing from that ministry's budgets and so on. That will very well have implications for how much research will they do, not do, and so on. So they wanted to set it up under the NBRA, and many of us argued that no, there are other ministries. If you want, put it under the Ministry of Health. Or right now, this exists under the Ministry of Environment, the GEAC. But we were arguing for Ministry of Health. This also has expressly somewhere written in the explanatory text, not in the bill itself, not in the draft bill itself, that this is about single window fast track clearances. So a question around that is, who wants these single window fast track clearance systems? Is this entire setup meant to facilitate clearances? Is that what it is for, or is this to protect the health and environment of this country? That's another key question. Decision-making process just in the hands of 4 people, like I said, it very clearly says that they will form the committee. The final decision-making will be right now. Even a 30-member body does not seem to be asking all the right questions. And 4 members sitting in the decision-making body, one can imagine what that will lead to. Risk assessment not going beyond biosafety is exactly what I was talking about. This is not just about technical issues. If you want to really say, I am creating the NBRA because the Swaminathan Task Force said that this is what is required, then we've already seen what the cornerstones that they had laid down was. We've seen that earlier. Livelihoods, trade security, there were so many issues. There's no provision that's been created in this draft bill for reviewing, for monitoring and for revoking approvals if needed. Those were some of the things that we already listed down as key elements that any legislation should have. There's been no provision included for liability. One of the things that has been pointed out with EPA 1989 rules was that you don't have any liability mechanism right now, which takes care of penalties, which takes care of compensation for the ones affected, which takes care of remediation to clean up when things go wrong. All those 3 are core elements in any liability regime. It doesn't exist in 1989 and no mention of it in the NBRA proposals. No redressal, no remediation. And for some strange reason, they don't, say that this will cover storage, this will cover distribution, this will cover export. You must have seen what it says. It talks about use, it talks about import, but several other aspects related to regulation were missed out. State governments are being left out, like they've been left out right now in the 1989 rules. More importantly, they have tried to include a clause that says that any state level legislations related to GM regulation and GM decision making will be superseded by this law when it comes into effect. And this had happened at a time when Kerala and others were already taking a decision that they will remain GM-free states. So they consciously tried to include that, which is actually one can argue that it's a constitutional violation, given that agriculture is a state subject. No prior informed public consent. You had listed that down as one of the key elements at 2 levels, both at the farmer level and at the consumer level. No prior informed consent. They also talk about their own ways of, approving the release of seeds. In this country, there's a well-established system of when seeds will be allowed to be released in the market. Around the 1980s, the private sector in any case came in a big way and broke all those rules when everything was opened up. But to this day, for a notified variety of seed to be released, it goes through rigorous testing. 10 years before a release committee actually allows even a public sector variety to be released. But here they want to bypass the existing seed release mechanisms. And they have mentioned a point saying that decisions will be made public later, after the decision is made. So they are not talking about decision making being participatory, they are only talking about decisions being made public. On GM foods, they tried to undermine the Food Safety and Standards Act that already exists now, which is meant specifically to regulate GM foods. The mandate for the 1989 rules is to look at health and environment safety in a big overarching way, which they don't do in any case. The Food Safety and Standards Authority in any case is struggling with trying to delineate its own role, because in the case of genetic engineering, any unprocessed GM product is considered as a living modified organism. A brinjal, for instance, has life, it has those seeds inside. So it's a living organism. Let's say a brinjal pickle will be a GM food product. It's been processed and so on. So they can't clearly figure out whether FSSA should get into GM foods which are living modified organisms also, because the GESC is saying no, that's our responsibility. So these guys are trying to say that, okay, we'll look at only processed food products. And the NBRA adds to the confusion, which says that GM foods will also be included in the NBRA. Then what will FSSA do? Sitting there as a separate statute. The appellate authority is a one-member